I do believe that the bond should reflect the charges. I think that Ypsilanti has a serious issue, which you probably know a lot more intimately than we do with respect to what's going on. But like,
I don't know what you want me to say.
Preparing it is a lot of
Ypsilanti,
shock.
but that's not going to happen. Ypsilanti is a wonderful city with wonderful people.
It's a wonderful city, but there's a problem.
Every place has problems.
Right.
I don't think
problem.
I don't think Ypsilanti is any different than any place else. But I'll let you go ahead. But you start attacking my home, we're gonna have a
I'm
problem.
not trying to.
Specific waiver, and I'll put it on the record. It's my understanding that Mr. Sweat will be despite the examination and it would be on the how I show the charges, and hopefully it's the same way the court sheet. Count 2, weapon. Count 3, weapon possession by a prohibited person or felony possession, and then count 5, 1 count for felony firearm. Those 3 counts only. Count 1, discharge from a vehicle causing death. Count 4, open murder, and count 6 and 7, both felony firearms would be dismissed on this waiver.
Count 1, 4, 6, and 7.
Yeah, 6 and 7.
Okay.
So effectively, Mr. Sweat is waiving up on 3 weapons-related charges for further proceedings in circuit court.
3 down. Take a look. Was there an amendment?
Man, he got murder charges and he got killed somebody with a vehicle.
At some point.
So looking at the amended.
I got to find it only because on the original, I have the 3 counts and there had to be an amended because the homicide comes forth. There it is. All right.
So on the amended, it would be 2, carrying a concealed weapon, count 3, possession by a prohibited person, and count 5, felony firearm.
Yes.
Well,
count 5 and 6 are felony firearm.
it would be actually the count 7 felony firearm because it would be the felony firearm connected with the possession by a prohibited person.
Got it. Okay. So, got it. Let me just redo this.
And of course, Your Honor, I will make sure that an amended information is filed in circuit court.
Correct.
To accurately reflect this.
Okay, so what I have is that he's going to waive up on counts 2, 3, 7, and that counts 1, 4, 5, and 6 would be dismissed.
Correct, Your Honor.
All right. Starnwell, is that your understanding?
Yes, Judge.
All right. Mr. Sweat, you understand that, sir? Yes, sir. And you're waiving your right to a preliminary examination on those charges? Yes, sir. All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. You understand you'll not have that hearing, you'll proceed to circuit court on these charges. All right. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2, 3, and 7. Counts 1, 4, 5, and 6 are dismissed. As to the circuit court arraignment, Ms. Barton,
Your Honor, we waive a reading of the information and stand mute.
waive oral reading, standing mute to charges 2, 3, and 7. Court will enter a not guilty plea. Pre-trial will be set for
February 18th at 1:30 with Judge Conlon.
February 18th, 2026, 1:30, Judge Conlon.
Your Honor, I wanted to address bond.
Yes.
My client's been incarcerated for 7 months now, or almost 7 months. The prosecutor this is a dismissal of the homicide charges in good faith. I'm pretty sure that the prosecutor has looked at the evidence, and when I spoke to him, that was conveyed to me. So, Judge, I'm respectfully asking that this court grant my client a bond where, even with a tether, Judge. My client, before being arrested here, did matriculate at community college, which was at Washtenaw Community College.
Response.
Thank you, Your Honor. I will, regarding the defendant's criminal history, there's 2016 carrying a concealed weapon. It was under HIDA, a 2025 RNO, a 2023 felony destruction of police or fire property, a 2023 domestic violence, and a 2023 home invasion second degree are what I show as prior criminal convictions. Everything I do is in good faith, but I don't disagree with Ms. Barnwell. This is not a plea agreement. This is not in exchange for something. This is a discussion with Ms. Barnwell, discussion with the police, and a careful consideration of the facts of this case. This is not putting forth a case to this court at preliminary examination on something that we cannot prove. So that is why we've elected to allow this waiver on the charges before the court here today. I would be remiss in acknowledging that the defendant was positioned in a vehicle where the driver of that vehicle, the co-defendant, Devontae Owens, shot and killed Dejan Ryan on the date that this murder took place. Prior to that taking place, Mr. Sweat was engaged in a heated altercation with Dejan Ryan's in a McDonald's around the corner, basically at Ecorse in Michigan, and then that led to the shooting that eventually took place by the co-defendant. Obviously, if Mr. Sweat was involved and actually shot, we would be in a different situation. We're not. But I think that it's important to have context as to why we have these associated weapon charges. I still, despite the fact that we not only have some felonies, have concerns for the safety of the community, given the circumstances around these possession of firearm charges. I would request the bond's probably denied at this point, right?
Well, what do you show? Because I show as bond at, but that may have been from the original charges. I show as bond at 1 million cash surety.
I believe that is still correct.
That is so correct. His current bond is, as originally said, at 1 million cash surety.
I did miss one important conviction in 2017. He was convicted of possession of a firearm by the U.S. Attorney's Office.
So he did federal prison time. I'm not sure.
I would request, I'm not going to ask for $1 million bond charges before the defendants, but I would ask for a $50,000 cash or surety bond with a tether if he posts that bond.
Anything else, Ms. Barnwell?
And I'd respectfully ask for much lower. My client is, I don't want to litigate the case in front of this court. I really don't want to litigate it in front of this court, but everybody here is not clean, including the complaining witness. So it's like a dangerous situation. And I think my client's life is in danger too. I really do. I've been around, we have argued unsuccessfully, and then somebody dies. So, Your Honor, I will still stick to my argument that the prosecutor had a lot of months to contemplate, to look up to, and do all of this stuff. We had lots of stuff that we went through in terms of evidence with respect to my client. We took opportunity here today. But I do believe that the bond should reflect the charges. I think that Ypsilanti has a serious issue, which you probably know a lot more intimately than I do with respect to what's going on. But like,
I don't know what you want me to say.
Preparing it is a lot of
Ypsilanti,
shock.
but that's not going to happen. Ypsilanti is a wonderful city with wonderful people.
It's a wonderful city, but there's a problem.
Every place has problems.
Right.
I don't think
problem
Ypsilanti is any different than any place else. But I'll let you go ahead. But you start attacking my home, we're gonna have a
I'm
problem.
not trying to. All right. So
I understand what you're saying, that there are issues, but I think those issues arise in our society in a lot of places. I don't think in a lot of ways that the city of Ypsilanti or the surrounding communities are any different.
the size of it makes it more pronounced. It's a small community. However, Judge, I don't want my client to be harmed, but I don't think that he is the big threat in Ypsi. He wants to continue to school. These 7 months have meant a lot to him. He has, in minutia, looked at discovery, and in fact would like to continue school as a paralegal. He wants to. I've known lawyers who have convictions there. So I think that this will help him. And so I don't think he should be branded
he and his friend murdered another friend. They had an argument in a car, and that's what happened. So, and now they trying to, his bond was $1 million. Now they trying to get it to 50,000. Now they trying to get it to the lawyer's trying to get it to a lower bond because she says everybody's in this whole situation will have some retaliation for all this.
So I'm asking for a reasonable bond. Whichever.
And if I look at and think context is important, and people have pointed out some context to it, but if I look at the charges in and of themselves, I will reduce his bond, but his bond will be set at $100,000 cash surety. He must have a GPS location tracking tether prior to his release. I'll need a form.
Thank you, Your Honor.
Thank you.
Don't let anybody. All right. Thank you, Judge. Have a good day, everybody.
Thank you.
Sorry, we got a second for pre-trial date?
February 18th.
Thank you.
We got one. All right. I got you out in time, Barnwell. You better get down to Kunky. I'm gonna call her and say you're just like wandering around not doing anything. And that you